All right, ma'am. Mr. Lopez is here.
All right,
Recording
very
in
good.
progress.
Good morning, sir. My name is Emily Curington. I'm a county judge who is here to do your first appearance hearing. There are 3 issues that I am here to decide. First, I will advise you of the charge or charges against you. You were here on a warrant that was issued by a judge who's already found probable cause to believe that an offense was committed and that you committed it. But I will advise you of those charges. I will then consider the issue of bond. In determining whether to set a monetary bond, how much, and any conditions of bond, I will consider a number of factors, including the nature of the offense charged, the potential penalty, whether you were on probation or out on bond for another offense at the time the new offense was allegedly committed, your ties to the community, your prior criminal record, your financial status, your employment history, any record of failing to appear at prior court proceedings, and the nature and probability that you might present a danger to the community. The third issue I will address with you is the matter of counsel. Your attorney, who has announced her name and presence for the record, is sitting to my left. She's not able to get into the jail in the secure part of the jail where you are, so she came to my office and she is here for that purpose. This proceeding today is being recorded. You have the right to remain silent. Anything you say could be used against you in later proceedings. You have the right to communicate with your lawyer, with your family, and your friends. Reasonable means will be giving you the opportunity to do that. Can you raise your right hand so I can place you under oath? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do, ma'am.
Thank you. Could you tell me your name, please?
Marcos R. Lopez.
Mr. Lopez, you were here this morning in Lake County case number 2025 CF 1479. It's a warrant that was issued for you for 1 count of racketeering and 1 count of conspiracy to commit racketeering. Attorney for statewide, I believe, is here. Would you like to be heard as to the setting of bond and any bond conditions? I know you filed a motion about the source of funds today, so if you would include that in your remarks, I'd appreciate it.
Yes, Your Honor. Panayota Papakos for the Office of Statewide Prosecution. As far as conditions, the state would be seeking an electronic GPS monitor as a condition of any release. We would ask that the court order the defendant to turn over his passport to the clerk of court. We would ask that he forfeit any and all firearms in his possession. And further, Your Honor, at this time, the defendant is charged with 2 first-degree felonies. So the state would be seeking a $600,000 bond as to each count for a total of $1.2 million. And I will go into essentially the criteria that the court has previously announced. First, the nature and the circumstances of the offenses charged justify this amount of a bond in this case. The state has filed an affidavit. I believe that the clerk filed it in separate sections because it is 255 pages. And so I provided it to Your Honor's judicial assistant this morning. And just some highlights that the allegations in that affidavit, the detail an extreme breach of public trust, the circumstances surrounding his misuse of office as the sheriff of Osceola County are very serious. Again, there's direct evidence in that affidavit of ongoing illegal enterprise. The weight of the evidence includes that the defendant obtained between, at the very least, $600,000 to $700,000 since 2020 from this illegal enterprise in cash payments. There is evidence in the affidavit of a wire transfer to a bank account he controlled through a fictitious business name. There's direct text message evidence from both WhatsApp and cell phone applications of his involvement in this enterprise dating back to 2019. Beginning on page 110 through page 148 of the affidavit, there are numerous text messages from the defendant directly to co-conspirators. The first co-conspirator being Miss Zhang, also goes by Kate. Those direct text messages evidence that he was using his influence as the sheriff even prior to election, indicating he was very respected in his community to facilitate the illegal enterprise. There's screenshots of slot machines and things of that nature in those text messages. Of note, I would direct the court to page 175, where the defendant was actively sourcing new locations for illegal businesses to come in from Lake County to Osceola County. That began in 2021. And then further on, beginning on page 229, there are text messages between the defendant and co-conspirator Krishna D. O'Karen. Your Honor can see some of the affidavit is redacted, but there are photos of active law enforcement officers that have responded to those locations. I'm sorry, there's some audio interference. There are photos evidencing the defendant's direct involvement and also using his influence to potentially obstruct criminal investigation into these businesses in Osceola County. So that would be the first two factors, the nature and circumstances, and then the weight of the evidence, again, evidenced in that detailed affidavit that was completed both by HSI task officers and the Florida Department of Law Enforcement. So there was two co-affiants in that case, with the understanding that this is a joint investigation. The defendant does not have any ties to Lake County that we are aware of. He has been suspended from office by the executive order of the governor. And moving on to subsection F, the source of funds, the state has filed a motion this morning, and I've provided it to the judicial assistant in its entirety. But essentially, this is a motion where we would be asking the court to inquire into the source of any funds that the defendant would use to post bail, or that you'd be using for collateral. Essentially asking the court that prior to posting that the defendant show that these are not funds derived from any illegal enterprise or any illegal proceeds. And I would rely on the written motion essentially that the statute allows the court to conduct that inquiry. And so we would ask that any release be stayed until the defendant meets his burden of showing that those funds are from non-criminal sources.
Anything else?
Not at this time, Your Honor.
It's Abraham.
Your Honor, $600,000 is a very high bond for the nature of this crime. Mr. Lopez has no criminal history. He has extreme ties to the community in Osceola County, which is still within the state of Florida and not very far from Lake County. He does have a family. He was publicly elected for 2 different terms as a sheriff's office. He does have funds from working at the sheriff's office. This is a white-collar crime, a non-dangerous crime. There is no indication that Mr. Lopez would be a flight risk in any way, or that he would not attend any of his court hearings. He has employment history. He does have financial resources. He has family and friends that are supportive to him as well. We would ask that this bond be set in the amount of $25,000 in each count. As state indicated, he no longer has his position at this time, so a $600,000 bond for each count would be tantamount to no bond at this point. When speaking with his family, there was indication that $25,000 on each count would be affordable to the family. Although Mr. Lopez has a title, we would ask the court to still look at Mr. Lopez as a regular individual, and not just because he has a sheriff's title that he should be treated any differently. This is a racketeering charge. These are first-degree felonies. We'd be asking that his bond be set in a reasonable amount that would be affordable to his family, and that each count would be set in an amount of $25,000. In terms of conditions, there is no indication that Mr. Lopez would be a flight risk in any way. Mr. Lopez would agree to turn in his passport. In terms of having a GPS, if Your Honor would like for him to have a curfew, I believe Mr. Lopez would comply with that. I don't see the need for a GPS. This is not a violent crime. He is not a danger to society. This is a white-collar money crime at this point. GPS monitor, defense would argue, is not necessary at this time. He would comply with the conditions of no contact with any co-defendants in the case and surrendering his passports. Again, with the firearm condition, this is a non-violent crime. He's not a danger in any way. He doesn't pose a danger to the community. So we'd just be asking Your Honor to set conditions and a bond in a reasonable amount. Thank you.
Anything else?
Your Honor, briefly, we have HSI Task Force Officer Frank Tegler, as well as FDLE Inspector James Frank was on the line. There, in the course of this investigation, they determined that the defendant has traveled to Puerto Rico and there are ties to Puerto Rico. So that was the reasoning behind asking for, first of all, with the understanding that it's still the United States, we were asking for a monitor.
Anything else?
And then no contact with the co-defendants. I don't believe that I said that.
You didn't, but Ms. Ibrahim mentioned it and I had it in my notes to impose that as a condition. Anything else, Ms. Ibrahim?
Just because he has ties to Puerto Rico or that he's been to Puerto Rico still does not indicate that he would be a flight risk or not attend any of his court hearings that are required of him. So we would be arguing against the GPS monitor as a condition. In terms, and Your Honor, my apologies, in terms of the money income, he has been working at the sheriff's office, so he does have legitimate funds to be able to use to bond himself out.
All right, I am going to set bond in the amount of $500,000 on each of the 2 counts for a total of $1 million. I will require Mr. Lopez be fitted with a GPS monitor prior to his release from custody should he post the bond that I just set within 72 hours of release from custody. You'll be required to surrender your passport to the clerk's office for safekeeping, Mr. Lopez. You will be required to surrender any firearms in your possession to law enforcement. Which agency, Ms. Papakos, do you think would be most appropriate? Florida Department of Law Enforcement?
Yes, Your Honor.
That's what I assumed, to FDLE, and I will put that in my order that within 72 hours of any release from custody, all firearms in Mr. Lopez's your possession will have to be surrendered to the Florida Department of Law Enforcement. You may not have any contact whatsoever with any named co-defendant in the case, and I will make sure their names are in the order. Your next court date for right now is June the 30th, so I'm sure your attorney will be in touch with you. Anything else?
No, Your Honor.
No, Your Honor.
Is that the
Alright.
bond?
I'm sorry, somebody asked a question, I think. I'm not sure who.
How do I start the bond process?
So your attorney is likely to come talk to you in just a few minutes. She's probably going to come across the street, Mr. Lopez, and do that. If that doesn't happen, they're going to let you reach out to your family and to your friends. Also near the phones over there is a list of bail bonding agencies. You might want to try that as well. But I think your attorney is likely going to leave my office here shortly and come talk to you. So you can chat with her whenever she comes over in a few minutes.
Okay, thank you.
And Your Honor, if I may.
Certainly.
The NIMBY hearing is not necessary.
I am going to grant the state's motion as far as the source of funds goes pursuant to Florida statute 903.0462F. So the source of the funds will need to be shown to the state. If that's not satisfactory, you all will need to have a hearing in order for Judge Welke, who this case has been assigned to determine if the source of the funds has been appropriately shown. If the state agrees, you all can file a stipulation to that.
Your Honor, may
Yes,
I
Your Honor.
request that a hearing be set on Monday?
I would not have the jurisdiction in order to do that, and I do not have access to Judge Welke's calendar. You all are more than welcome to reach out to see if he can set a hearing today. I think that would be the best thing under the circumstances. I don't know what his schedule looks like, but I'm sure he'll get you hearing time as soon as he can.
Thank you, Judge.
Certainly.
That is all I have.
Anything else from the state?
No, Your Honor. I believe that there is one more co-defendant that was taken into custody, but I don't have information as to whether she's on the docket for this morning's first
I
appearances.
actually have 2 co-defendants, female on the docket who were taken into custody in this case, Ms. Frederick, and I'm not sure how I say the last name of the other person, Cote, I believe is her name, Carol?
Yes, Miss Cote, yes.
They are both in custody, and I will see them after I finish. I normally see all of the males, or as many of them as I can, who are grouped together, and then we move the computer so that I can see the female. So it's going to be a few minutes.
Okay,
But
thank you, Your Honor. I'll remain on the meeting.
both of them here in a few minutes.
Thank you.
You're welcome. Thank you.